With the authority of the Council, I shall now confer the degree of Doctor of the University, and I call upon the Deputy Vice-Chancellor, the Acting Vice-Chancellor, Professor Bill Lovegrove, to read the citation.
Chancellor, the Council of the University has resolved to award the degree of Doctor of the University to the Honourable Chief Justice Murray Gleeson, AC. Chancellor, Anthony Murray Gleeson was born in 1938 and educated at Sir Joseph's College, Hunters Hill. He graduated with Arts and Law from the University of Sydney. Murray Gleeson was admitted to the New South Wales Bar in 1963. During his early career, he was a tutor in law at St Paul's College, Sydney University, and later lectured in company law, also at Sydney University, until 1974. That year, at a relatively young age, he was appointed a Queen's Counsel. He served as a member of the New South Wales Bar Association from 1979 and became President of the association in 1984. During his distinguished career at the Bar, he developed an extensive general practice with significant expertise in equity, commercial and constitutional work. He was held in the highest regard as an advocate with formidable analytical and technical skills. He was appointed an Officer of the Order of Australia in the Queen's Birthday Honours in 1986. In recognition of his considerable talents and his standing in the legal profession, he was appointed as Chief Justice of the Supreme Court of New South Wales in 1988, an appointment which was the first in 50 years to have been made directly from the Bar. During Murray Gleeson's term as Chief Justice, the Supreme Court and the legal system in general faced many challenges and changes. These included the political debate and media scrutiny of sentencing decisions in the criminal jurisdiction, as well as the delay in the criminal justice system and the effects of this on defendants held in custody. Murray Gleeson initiated reforms to improve efficiency within the court, including the adoption of case management strategies and the appointment of a public information officer to the court. While serving as Chief Justice of New South Wales, Murray Gleeson was also appointed as President of the Judicial Commission of that state. In 1989, Murray Gleeson was appointed Lieutenant Governor of New South Wales, and in the same year he was made an honorary bencher of Middle Temple of the Inns of Court in London. His services to the law and the Crown were further recognised in 1992 with his appointment as a companion in the General Division of the Order of Australia. Murray Gleeson was appointed to his current role of Chief Justice of the High Court of Australia in May 1998. He is the first Chief Justice since Sir Samuel Griffith to have been appointed to the role of Chief Justice of the High Court directly from being a Chief Justice of a state Supreme Court. He was Boyer Lecturer for 2000. His lectures showed his deep understanding of Australian political and constitutional history, an understanding he was able to convey to a lay audience extremely well. The very successful lectures, entitled The Rule of Law and the Constitution, were subsequently published by ABC Books. It is fitting that Griffith University should honour Murray Gleeson, AC, in recognition of his distinguished contribution to the legal community. Chancellor, it is with the greatest pleasure that I present to you Anthony Murray Gleeson, AC, for admission to the degree of Doctor of the University.
I now call upon the Honourable Justice Murray Gleeson, AC, Doctor of the University, to deliver the occasional address. Chancellor,
Acting Deputy Vice-Chancellor, Pro-Vice-Chancellor, Dean, ladies and gentlemen. I'm greatly honoured by the award of the degree that has been conferred on me. And I'm also honoured to have the opportunity of participating in this ceremony at which the achievements of so many scholars are being marked by the university. The formality associated with graduation ceremonies is a public acknowledgement of the importance attached by the university and the general community to academic success. I congratulate you all. Although some of you have graduated previously, for most this marks the completion of your undergraduate course of studies, and you're all entitled to be proud of your achievements. You're also entitled to look to the future with confidence and enthusiasm. It's a delight to share this occasion with you. Many of you, no doubt, owe a great deal to the support and encouragement that you have received over the years from family and friends. Although some may come from families with past university associations, I expect that most of you, like me, belong to the first generation in your families to have had the opportunity of a tertiary education. Many of you have been able to take advantage of that opportunity by reason of the support of others who were not themselves so fortunate. They share in your success, and occasions like this are intended to honour them too. This university, young in age, has already established a fine reputation as a progressive and innovative centre of learning. It's named after my great predecessor, Sir Samuel Griffith, the first Chief Justice of the High Court of Australia. He and I have at least two things in common. As was mentioned earlier, we're the only former state Chief Justices to have become Chief Justices of Australia. And I'm sure you won't think I'm abusing your Queensland hospitality if I mention that he and I both graduated from Sydney University. But Sir Samuel Griffith never graduated in law. All three of the foundation members of the High Court, Chief Justice Griffith and Justices Barton and O'Connor, were graduates of Sydney University, but they graduated in arts, not law. The Faculty of Law didn't commence at Sydney until 1890. A degree in law was not, and still is not, a necessary requirement for admission to practice as a barrister or solicitor. Until quite recently, a number of the most senior English judges had no law degrees, having done their undergraduate studies in other disciplines. The assumption was that legal knowledge was something to be gained by experience and practical training, rather than theoretical discourse. This isn't to underestimate the great contribution to the law that has been made by the universities. The development of legal theory at an academic level is now recognised as indispensable. But it is worth remembering that many great judges of the past, including Sir Samuel Griffith, learned their law in a different way. I'm sure that it has been the purpose of the university in conferring this degree more to honour the High Court as an institution than me personally. I hope that today's science graduates, as well as the law graduates, will take some interest in that institution, which was famously described by Alfred Deakin as the keystone of the federal arch. My purpose this afternoon is to seek to encourage that interest, and my remarks are directed as much to the scientists as to the lawyers. The federal union between what had formerly been separate, self-governing British colonies was achieved 100 years ago. It was the result of protracted negotiations and political compromises that extended over more than 10 years. The terms on which the final agreement for union was reached were embodied in a written constitution that was approved by referenda and parliamentary votes in each colony, and that took legal effect by virtue of an enactment of the Imperial Parliament. The word federal comes from the Latin for a treaty. The essence of a federal system of government is an agreed division of legislative, executive and judicial powers between a central government and the governments of the constituent parts of the Federation, that is, in Australia, between the Commonwealth and the states. A federation requires a formal, written instrument which embodies the agreed division of powers, and that's the Constitution. At the time of federation in Australia, there were three possible federal models: the United States of America, Canada and Switzerland. It was the model of the United States that was most influential with the founders, although they didn't follow it in all respects. The two most notable differences were that Australia was established under a constitutional monarchy, and that Australia, unlike America, followed the Westminster precedent of responsible government, by which the executive required the confidence of Parliament, or more accurately, the House of Parliament that represented the people. As in America, the federal Parliament had two houses. The Senate was originally intended to represent the states, and the House of Representatives was intended to represent the people. The role of the Senate has evolved over time, but that was the original idea, and it explains why each state has the same number of senators regardless of population. That was part of the bargain by which federal union was achieved. The demarcation of the respective powers of the Senate and the House of Representatives was a major issue during the negotiations for the Constitution. Clearly enough, a written agreement dividing governmental powers is certain to give rise to disputes about its meaning and effect. The founders, following precedent both in the United States and in the Australian colonies before Federation, assumed that the ultimate resolution of disagreements about the meaning of the Constitution would involve an exercise of judicial power. Such an assumption was not self-evidently correct, although it isn't easy to see a practical alternative. At all events, the assumption was made. Just as the Supreme Court of the United States was and is the final arbiter of disputes about the meaning of the United States Constitution, so it was to be in Australia. The Constitution required the establishment of what it described as a federal Supreme Court to be called the High Court of Australia. Subject to the possibility of appeals to the Privy Council, which were always limited and which were finally abolished in the 1980s, the High Court was to be the ultimate interpreter and enforcer of the federal agreement. It's that role of resolving disputes between governments or disputes between citizens and governments as to the meaning of the Constitution, and of settling disagreements about the division of governmental powers and functions within the Federation, that gives the High Court its distinctive character. The political and social implications of the way in which the Court goes about exercising that responsibility are obvious. The Court decides cases about the extent of the powers of democratically elected parliaments and about the allocation of executive and judicial power within the Federation. As former Chief Justice Sir Owen Dixon pointed out, the people and governments of Australia, as parties to the federal agreement, entrusted that responsibility to the Court on the faith of a certain understanding. The understanding was that the Court would approach its function with strict and complete legalism. Legalism doesn't mean the same thing as literalism or formalism, but it requires adherence to legal principle and method, fidelity to the federal agreement, which is the task of the Court to interpret, not to alter or rewrite, and an acceptance of the constraints of judicial legitimacy. The founders and the people committed the task of interpreting the Constitution to a body of unelected lawyers on the understanding that they would approach that task in the manner of lawyers, bringing to it their legal skills, not their political and social enthusiasms. Sir Samuel Griffith made this point firmly in a judgment in 1904 when he said, "I hope the day will never come when this court will strain its ear to catch the breath of public opinion before coming to a decision in the exercise of its judicial functions." Of course, there's room for legitimate difference of legal opinion about the techniques of interpretation of a written constitution. If it were otherwise, there wouldn't be any constitutional cases. If the meaning of the Constitution was in all respects plain, or if lawyers all agreed as to how to go about resolving uncertainties, there wouldn't be any need for a court to interpret the Constitution. Any lawyer would be able to tell you what it means without contradiction from another lawyer. Today's law graduates would immediately recognise that as an appalling state of affairs. But the task is one of interpretation, not of creativity. It's the express or implied meaning of the text that is controlling, not the individual opinion of a judge as to what the Constitution ought to say. No doubt it's more exhilarating to formulate ideas about what a Constitution ought to provide than it is to address the task of finding out the meaning of a text written 100 years ago in its application to current circumstances and conditions. But for a lawyer, that task provides more than enough challenge. The framers of the Constitution knew that the document they drafted would have to be interpreted and applied in future circumstances they could not foresee. As an instrument of government intended to last long into an unknowable future and intended to be difficult to alter, the Constitution is dynamic. It was never meant to be read as a piece of parchment sealed in a time capsule in 1901. But at the same time, it embodies the terms on which the people of Australia agreed to federate and on which the separate self-governing colonies agreed to surrender part of their powers to a new central authority. Those terms were expressed and communicated to the future in writing. It's the meaning, express and implied, of the language of the instrument that controls the outcome of disputes about the division of government powers. If the High Court were to be seen not to seek and apply that meaning, but to rewrite and alter the federal agreement, then the foundation of the federal union, the agreement by which it was constituted, would be destroyed. If the governments of Australia, federal and state, and the citizens had no confidence that the courts would adhere to the constraints inherent in the role entrusted to the judicial arm of government, if they apprehended that the members of the High Court felt entitled to devise a new constitution different from that agreed upon, without observance of the democratic process of amendment that's built into the Constitution, if they concluded that the faith of the founders in the judicial role was misplaced, then the structure that was devised for the peace, order and good government of the Commonwealth would fall apart. Judicial legitimacy and adherence to the techniques of legalism is not dull and conservative. As G.K. Chesterton said of another kind of orthodoxy, to be sane is more dramatic than to be mad. Anyone can think up ways to alter the Constitution, to resolve great issues about the federal division of governmental powers by interpreting and applying the language of the federal agreement with all its legitimate implications is a proper task for a judge. To maintain public confidence in the integrity with which the judicial arm of government approaches that task and in its fidelity to the Constitution is a continuing challenge. No doubt there are people in the community who wish we had a different Constitution and who are impatient with the apparent difficulty of securing the necessary popular support for change. But it would be a serious mistake to look to the court to supplement what is regarded as a deficiency in the democratic process and to amend the Constitution by an exercise of judicial power. There is no such power. The only power of the court is that conferred on it by and under the Constitution. For the court to disregard the meaning of the instrument, which is the very source of its own authority, would be to undermine its own authority, and it would be to demoralise those upon whose consent all the institutions of government ultimately depend. To many, the judiciary will appear unadventurous, but that's because of the nature of the task that has been entrusted to it. Reliability can be boring, but when you consider what it is the High Court is being relied upon to do, you might see it in another light. Justices of the High Court frequently disagree among themselves about the interpretation of the Constitution, and decisions of the Court are a legitimate subject of comment and criticism by lawyers and non-lawyers. But there's one form of criticism that should cause people to pause and think carefully. When you hear it said that decisions of the Court are legalistic, you should ask what else they might be. Members of the High Court are appointed on the basis of their legal experience and capacity. It would be unwise to complain that they behave like lawyers without considering the alternatives. I thank the University for the honour it's shown me and the Court, and I wish you all well in your future careers.